Good afternoon, and thank you for joining us today. I would like to welcome you to part two of FortneyScott's Workplace Legal Compliance webinar series entitled Compensation Reviews in the Changing Legal Landscape. This webinar will be recorded. Today's presenters are FortneyScott attorneys David Fortney and Elizabeth Bradley, and the guest speaker today is Rick Holt. I will now turn the program over to David to start the webinar.
Sarah, thanks so much and welcome everyone. We're really glad to have you join us in this. We focus this fall on really locking in on some of the key compliance challenges that so many employers, federal contractors, and non-contractors face. And we're going to really hone in on comp reviews, which is so important. And we note as we're in the fourth quarter, the run-up, this is when most organizations are thinking about their budgets for next year. And the comp process typically spools out pretty heavily early in Q1 of the calendar year. And so having your ducks in a row and understanding these, and hopefully this is a refresher course for some, but we know for some it won't be. Well, let me first introduce Rick. Let me just say a little bit more about you. First of all, we're really glad to have you here.
Thank you.
And we're all gathered down in Washington. Not many people do that, but here we are, and we like being here. But Rick is a partner and a labor economist with Resolution Economics, a great firm that we work with a lot. We work with Rick a lot. And Rick, we really appreciate you taking time to come over and join us.
Absolutely.
Of course, Liz, I think is well known to all of our clients, is an extraordinary lawyer, very capable, and spent a lot of her efforts in these areas of compensation assessments. So both she and Rick have worked on a number of projects together. And independently, so we have a lot of group expertise here. So with that, let's just dive right in because I want to be smart about our time. Liz, why don't you just say a word about FortneyScott, and then Rick, I'll ask you to introduce Resolution Economics.
Absolutely. FortneyScott, we are a Washington, D.C. based law firm. We represent our clients in a lot of employment, workplace related matters, often before Department of Labor, EEOC, NLRB. And our attorneys bring significant agency and sort of DCI or DC insider experience.
Rick, let's talk about Res Econ.
Yeah, just very briefly, Resolution Economics is an economic, statistical, and financial analysis consulting firm. We have offices throughout the country, primarily in Los Angeles, Chicago, and of course here in DC and New York. Our goal is to bring expert advice in a wide range of areas, focusing on labor and employment. We help our clients both in a proactive consulting setting and also in a litigation setting, analyze tough questions associated with all kinds of labor and employment areas, such as wage and hour, discrimination, more recently, artificial intelligence. So yeah, that's a little bit about Resolution Economics.
Well, we're glad to have you. And of course, our goal is to avoid litigation or to at least be prepared if we have litigation. And today's session certainly will, I think, illustrate all those points. Let's just jump right into the agenda so we can hold ourselves accountable within the next 55 minutes. We're going to cover all this. Quick review of the legal framework. That is important. We're going to then get it kind of nuts and boltsy on project flow, what should be done, when it should be done. Going to go back and make sure that everyone leaves with a good understanding of compensation review fundamentals, modeling, and then we'll give you some takeaways. That's a lot, but we can get that done. All right, let's kick right into the legal framework. And Liz, maybe you can kick that off.
So I think it's really important to understand here on the next slide what has and what hasn't changed. And I will say in the compensation world, a lot has not changed. And I think that's what we all need to remember here. So yes, there's been a significant focus on illegal DE&I by this administration. How that is being focused here in the compensation world, it is looking at how you previously did your pay equity. How did you previously determine who received remediation and that review? And we're going to talk about how to avoid challenges of alleged illegal DE&I when looking at your comp. Executive Order 11246 was revoked. Federal contractors with the compensation part of that, you no longer have a regulatory obligation to evaluate your comp systems under 11246. That's really the only significant change that 11246 has with regard to compensation. Another piece is EEOC is not enforcing disparate impact theories. That's being if you have a facially neutral process, it has a discriminatory impact. EEOC isn't going to be going after those claims. Now, they're still going to be going after class actions if it is a pattern in practice, meaning there's some sort of intent in that. So, these group large class action claims aren't going away even if with the EEOC. So then what has not changed? More has not changed than changed, as I said. So federal, state, local prohibitions on compensation discrimination all still stand. Disparate impact theory enforcement, federal courts, state, local agencies, courts, they are still going after those types of claims. Plaintiffs' counsel, they haven't gone away, right? They're still looking at those. And another big push is your stakeholders, your employees are still demanding equal pay. So or pay equity, I should say, looking at how you're paying and evaluating whether you have any unlawful disparities that violate Title VII, or thinking about the Equal Pay Act. That is still really an act that is getting more and more legs. So as you're making adjustments, making sure you're not elevating men over women in areas that are going to Equal Pay Act claims. So again, the legal landscape, a lot of spin about illegal DE&I, but I think the foundation that supports proceeding to do pay equity is still there. And
Yeah, I would agree. Just a couple of thoughts on this. I think many people conflate or confuse illegal DEI as somehow implicating sound assessments of your compensation practices with Title VII as the pole star. And to Liz's point, nothing has changed in that space.
Correct.
Nothing. And I am concerned because we have heard clients as they have responding to these what changes have occurred, saying, well, maybe we don't need to continue our pay assessments, or maybe we shouldn't be doing that anymore, or maybe that'll be viewed as illegal DEI. If done correctly, it is, first of all, it's not illegal DEI. It never was, and it should not be going forward. And number two, it needs to be done in terms of legal compliance. Number three, and many organizations on this webinar are international in scope. There is more of this coming. We're going to focus on the US today, but in 2026, the EU is going to be broadening the obligations to do analytics, to do reporting, et cetera. So this is something I hear from a lot of clients, like how much of our muscle strength do we disassemble in our HR and compliance team? Do not touch your pay review process.
And just a quick note, in addition, obviously we're focusing here on the context of pay equity, disparities with respect to race and gender in pay. But a lot of companies pursue these compensation analyses just to learn more about how they are compensated without regard to race or gender. Just are they paying people in a disciplined way that's consistent with their stated policies and practices? And so there's nothing. I just echoing what you
Excellent
said.
point.
Measurement is fine. Previewing what we're going to get to later. The challenge, the question is what you do with those measurements.
Right.
I think that's a little bit, and we'll get into that, but increased use of race agnostic analyses.
Right.
Well, let's just to drive the point home why ignoring this can have consequences. Just quickly examples of some recent settlements. And these are, albeit California based, so everyone kind of goes, well, I'm not in California. California, again, the scope and coverage of California is expanding. But nonetheless, this is what's on the books. Google with a $28 million. These are race-based compensation cases. Note that the go forward, it isn't just that there's the monetary. These are significant monetary settlements. Google 28, Disney at 43 million, that is. But there's the go forward includes having monitors, having reporting. So now the company usually compensation decisions, particularly at the top of the house, and with respect to what the systems, what the corporate values, to the point that Rick's really raising, are very closely guarded. I mean, those are they're about the corporate values, as Rick noted. And in these settlements, you basically have a third party. You may be required to use an economist, but almost always there's a reporting mechanism, either back to the government enforcement agency, back to the plaintiff's counsel, et cetera. And there often is a fair amount of publicity that is attached to it. And so these settlements have a long-term, I think, quite corrosive effect on an organization that has to do it, because it kind of takes away how pay should work, and you now have, instead of this internal discussion on corporate values and how we implement them lawfully and efficiently and effectively, you have this other chair or two chairs at the table, which usually is not someone who you want as part of that process.
Yeah, and I've had an opportunity to act as an independent reviewer, if you will, on part of these consent decrees. And one of the biggest hurdles I've seen, and beyond what you said, although you mentioned this in a prior discussion, is that the goals of the kind of settlement analysis plan may have made sense on the day of the settlement, but 2 or 3 years down the road, after a couple of acquisitions and divestitures and growth in the company, suddenly that analysis plan makes no sense whatsoever, but the company is still obliged to follow it. It's very, frankly, disruptive. I've seen it.
Which I'm sorry, let's just on one point. That's why the regular assessment of pay, because of the organizational dynamics, most companies hopefully are growing, some are not, but whatever the changes are, that almost always affects pay. Liz.
And I think taking, elevating this up a touch here is seeing that these two very large cases put in a requirement that you proactively, that you assess, do a pay equity analysis, shows the benefit of those analyses. So no, you don't want to be required to do so as part of a settlement and be by the rules of the settlement. But if you're proactively doing it yourself, hopefully you avoid that. And this gives you support that continuing to do these analyses is beneficial and viewed so.
All right. So I think we've demonstrated kind of why it's important for a whole variety of reasons. Let's now get a little more into the nitty-gritty and talk a little bit about how we do this and what project flow is. Like any major undertaking, we always use a project plan. Everyone at the table does, and I'm sure our clients do too, on any major undertaking. So let's look at the major components that are in a well-developed plan, just to introduce them. The attorney privilege, note that box is first. You cannot put that horse back in the barn. That must occur first. We will unpack some of this as we go on. Stakeholders engagement, the timeline, data collection, the purpose, and developing the factors, the actual analysis, and then the research results and remediation. And we have that circled and actually showing that we're not completely linear in our thinking. We're going to start with that end process. And we're doing that because it's interesting. All three of us agree from our experience, starting at the end and understanding what that entails, deeply understanding, helps inform and establish the timelines for each of the boxes leading up to it. So let's start with kind of that beginning. Let's start with the end, and then we'll, if you will, work backwards almost from there. All right.
And one piece on this slide, the coloring, so you understand the remediation, sort of what we're going to be recommending, and there's some changes in how some people have done the research remediation, directly impacts the first 3 steps of this. So understanding how you're going to do the remediation is going to drive the first 3 steps of the process. And we're going to go into that in a little bit more detail in a few minutes.
Okay. Well, let's delve right into the strategies. Liz.
Okay, so starting at the end of the story. So some of the things you need to be thinking about out there as you are doing your pay equity analyses, and there are remediation, research and remediation strategies that you should be considering if you were moving away from, especially in light of the current administration. So often we would hear about getting results, and you would have groups where the adverse impact, the flag was against whites or men.
Yep.
And those flags were not considered. Those were groups that were not researched. We need to be moving away from that thought process. If there are any groups, regardless of race or gender, minority or non-minority, male or female, any group that has a statistically significant flag needs to be part of your review process. That is kind of a foundation we need to be moving to. The next is an interesting one too, is limiting your remediation to only employees in the flagged group. What we mean there is often there would be examples where Asians are the highest paid and the flag was against Hispanics.
Right.
And you would go through and you would be reviewing and looking at the Hispanics at the bottom and making decisions about whether those individuals, Hispanics, need to be elevated. And you would be ignoring others who are potentially paid lower than statistically predicted, lower, whites, blacks, etc. The only basis for ignoring those people was on their race, right? They were not in a group that had an overall statistical flag, but when you're looking at the individual results, those individuals are still paid below predicted and they need to be looked at and being considered. And so again, any decisions based on who to look at based on race or gender need to be modified. And then also another remediation strategy that needs to be reviewed is those that only focused on eliminating the statistical indicators. So if you were looking at that and saying, well, we need to move up going back to the example before, Asians preferred over Hispanics, we need to overall increase the pay of the Hispanics in order to resolve the statistical significance in the pay disparity. That again is sort of closing a wage gap. And unless you have done the work needed to understand that each of those individuals actually needs a adjustment, those type of blanket sort of peanut butter approach of pay equity adjustments need to be reconsidered moving forward.
Those three trends that you just highlighted, they've been going on over the last 3, 4, 5 years among the people, companies I work with, but the Trump administration has just accelerated that. And I think those are just, as you said, strategies to reconsider.
Well, and I want to point out one thing, in listening carefully to the way Liz has identified that groups may be identified, but note that Liz is saying that you actually have to do the additional work of looking at the individuals that have been, quote, lit up to find whether an adjustment is or is not justified.
Right.
That is the key, and that will be the key if the EEOC comes knocking or plaintiff comes knocking. That is so important. And Rick, to your point, we certainly have seen clients in the past, and candidly, we have seen OFCCP's approach was almost always that. They always took the peanut butter approach.
Correct.
And so I understand why people think that, because that's been around for a long time. So this is a point, it's not legally different, but as a practical matter, many have been doing that for a variety of reasons. It needs to stop.
So the flag needs to be your starting place. It's not the end place. Exactly. Right. And so how you do that is your flag is a starting place. So one, review all groups that have a race or gender flag.
Yep.
Right. Then you're going to click down into that and look at all of the low outliers. By a low outlier, I mean anybody, regardless of race or gender, that is below the predicted. And you can set your parameters of where you want that to be. Is it 2 standard deviations below the predicted, or where you can be more or less work depending on where you are for each one of those individuals. And this is a lot of work. So, this is where we're thinking about, you need to go back and look at your time frame, but is their pay consistent with your pay practices? And how, but don't look at them in an isolation. Is their pay different from their peers? Right? Because somebody may be statistically low, but completely consistent with your pay practices because you have paid others outside of your pay practice and elevated them up. So when you look at individual by individual, you may not see an overall trend that is resulting in pay disparities that can't be explained based on your pay practices. Then you need to make determinations of individual remediation. So again, these blanket calculations of bring everybody up this much, or this is what you need to do, those are not going to be likely supported. You need to be looking at how much you need to increase individuals based on their actual peers.
I think those formulaic adjustment recommendations can still serve a role, but only as a starting point. They cannot be the be all and end all, I think, in this new environment. And what we'll see, to your point, is these statistical models, especially when they're framed in terms of a shiny interface, I think some people imbue them with a like magical accuracy. You have to, as a statistician or an econometrician, you have to stay humble about what your model can do and what it can't do. The pay setting process at most corporations is a myriad of factors, only some of which we can incorporate. And yeah.
So Rick, let's on the next slide we have what does this look like in the data?
Sure.
So I think that helps.
Yeah. So in this example, purely hypothetical example,
I'm really laughing because when you get to this point, typically in dealing with a client, they're like, oh, what is this?
This is when Rick and I get excited.
So
You know.
stay tuned. This is not scary. This is good stuff.
Go for it. Each dot represents a person in this similarly situated employee group. So we've run a regression analysis. Along the horizontal axis, you can see what the statistical model predicts, and I'm putting that in quotation marks, predicts what each person's salary is. Their actual salary is represented on the horizontal axis. The dots above that solid line, the 45-degree line, those are people who are paid more than expected. So based on the factors in the model, you have to add that, based on the factors in the model. The people below the 45-degree line are paid less than expected. The red dots are women, blue dots are men. Okay, now I've kind of set the table. Take it as a given that in this analysis, we found a statistically significant negative effect of being a woman. And so we are looking now at this group for further research. What we would often do is we would, and if you go back far enough, we would occasionally do this with clients, is we would look at the low side outliers, the individuals below the dotted line, parallel to the 45-degree line, and we would look at the 1, 2, 3 women who are below that dotted line. But note, there is also a man below that dotted line. And, if you want to oversimplify what we're suggesting here, we just want to send the message. We think it's pretty important these days to look at the salary of that man as well, because he is also paid, at least according to the model, statistically significantly more than the model expected. And by the way, as Liz indicated, how many of the low side outliers you choose to evaluate is a bit up to you. It depends on managing the workload of this process and the risk tolerance, because these individual reviews do have the potential to be a little burdensome. You have to look into each person, figure out what unique circumstances may be impacting their pay.
Yeah, a couple other things to be thinking about here too. If you get these results, one strategy I might do, because this is burdensome, so I'm hearing all of you guys out there, right? Do you maybe take a quick look at the person at the 200, that man up there?
Yeah.
What is it about him? Is he properly in the group? Is there something about him? Maybe he's been red circled. Do you pull him out and maybe rerun the analysis? That might remove the flag, because this may be a grouping issue and not a pay issue. So you need to be looking at each one of the results to figure out, do we need to do the individual assessment? What's going on here? And also, if you make the decision, you have to increase all of the 3 females and the 1 male.
Mm-hmm.
If they all need an increase, you may not get rid of the statistical indicator, and that is okay, because you've now looked at their pay, and it's all based on your policies and your business and legitimate non-discriminatory reasons. So don't focus on closing the.
One or two other things. I mean, Yes, there are some indicators. I like the suggestion that we take the outliers, we call it, before we delve into these cohort analyses, which are very labor intensive. Um, but then the adjustment itself, this was touched on, but I just want folks, the dotted lines show the two standard deviations. Sometimes we calibrate it to 1.96. Sometimes companies want a cushion, down to 1.5 or one standard deviation. Rarely, if ever, are you trying to get everyone to quote the line, because that the solid line, because that's just not life. And the comp system, unless you're in a highly prescriptive compensation setting, does not envision that everyone is paid. It's not purely formulaic. Now, if you have a collective bargaining agreement or certain federal sector workers are more formulaic, and you might expect that. But in a typical private sector, you will see this distribution. And that's because most companies have a component of merit or other aspects of performance that allows for pay distinction to occur. So you don't look at that and go, gosh, not everyone's lined up on the solid line. Well, that's okay. But the question is, can we explain and justify why they're not, and ensure that we go forward properly?
And always be thinking about the Equal Pay Act. So to the extent you do an automatic adjustment, if you end up adjusting a result of two employees in the same job under Equal Pay Act, and the male is paid more because you made some blanket adjustments up, then you have made a decision that it's not business related and it's based on gender alone, and you're going to end up with an Equal Pay Act. So that's the other problem really with gender when you're doing these peanut butter adjustments. So on the next slide, we're going to walk through some of the pros and cons of this. I think some of them we've already touched on, but I think it's something important for us to be considering. So one of the pros of this model is, so I think it should be on the next slide.
On the next slide, please.
So this is really important, is you'll be able to establish that the remediation is not tied to race or gender. And this is going to be less likely challenged under the theory of illegal DE&I. You're actually looking at business components and business justification and policy reasons for pay differences. It facilitates a comprehensive review of your policies and procedures. You're going to see, am I paying differently? Am I not being able to justify this on my policies? Do we need to make some policy documentation changes and updates? When was the last time all of that happened? And making sure that your pay is in line with the written documentation. And conceptually, it's pretty straightforward. The cons. It's time consuming, right? So you're not tying, you're not going to be closing the wage gaps, right? So you're still going to have the people trying to claim there's a disparate impact, right? But you're going to be able to defend those based on the business justification. So that's less of a con and more of a pro. It kind of goes in both. It is administratively very time consuming, and that's where we're going to have to talk about in later on, making the model is owned by everybody at the front end so that you are well positioned to do this review quickly and efficiently and get that set up.
And I just want to amplify, the wording of the first two bullets in the pro and con are kind of parallel, because on the one hand, you are insulating yourself with this alternative approach that looks at a review and remediation without regard to race or gender. You're insulating yourself against or minimizing the risk of that you be accused of doing illegal DEI. On the other hand, you could end up, after this process is over, if you were to rerun the analysis, you would potentially still have flags. But to Liz's point, that is okay because you've done the homework. You've done the additional digging and validated that the reason that flag still exists is that statistical model is not complete. You have to do more homework. And once you've done that, you've figured out, okay, there's an explanation for that, box checked. I'd be curious to hear what your guys' opinion on to what extent documenting that research is part of this process.
Oh, I think it has to be documenting. It has to be. I mean, I usually have in the outlier or the cohort reports, there's a notes page and it's initial review notes legal review notes, ultimate determination notes, and we walk through that decision-making process, because often, sometimes somebody who's going to flag, that's one of the first things that I do when I do an analysis and we have flags. Let's pull up the records from last year. Did we already solve why employee 1234 is paid less or paid high? Let's first cross-check our prior year notes. That takes a lot of the work out. So if you're developing this and keeping your notes in a consistent manner and developing this year after year, first year can be painful, but then you grow and you are able to use some efficiencies from the prior year. One other point I want to touch base on here is your measures of success have to change. Often you report out how many flags. This year we had fewer groups that flagged. That's not really a measure of success. What you need to be pivoting to is how much remediation or how many employees had to be corrected. So the amount of research and groups that flagged, that's going to fluctuate every year. But we got to a point where we only had 1% of the population that needed to be remediated, or looking at it in that lens rather than the number of flags. I think that's an important.
And I want to build out on that last point, Liz. I agree. And this really goes to, is our comp system doing what we want? Is it functioning not only to, recognize the values, the merit, all those sorts of things, but operating in a way that does not have potential legal exposure? And so these adjustments, to the extent they're necessary, that also should trigger a broader question of going back to the comp system. Why did this occur? Did we have a manager that wasn't trained well? Is it a weakness in our comp system? Are we not tracking all the data we need to be able to reflect the values that we have?
Because no, the number of groups that flag is more of a reflection on the accuracy of the regression model.
Right.
The number or percentage of remediations that need to be made, that's a reflection of your comp system or management discretion. And that's where we need to be living. And
that's where we need to live ultimately. And yes, our goal is to each year, hopefully, have fewer and fewer adjustments, but it's a combination of factors. It's having a comp system that functions as we want it to. It's having managers that are trained well and that implement it in the way intended, and that we're monitoring for that. And so, that's the bigger takeaway. And it's not just a one and done. That's the other critical point here, I think.
And just really briefly on the one and done, this box here just outlines that doing the research that we've been alluding to often points to potential refinements of the model. So this can be a somewhat iterative exercise, especially in the first year. And if you find data errors or data enhancements or new considerations, refresh the model. That can totally change the results, narrow the scope of the research review.
Agree. All right. Well, let's go back to sort of the beginning of the timeline and cover some of these foundational elements. So I'll kick off on that. We've mentioned a couple of times about the need for the attorney-client privilege. Obviously, as has been explained earlier by Liz, and I think people generally understand, this continues to be an area of focus, both by government enforcement agencies as well as private litigants. Full stop. Federal law, state law. I mean, pay, and there are still continue to be shareholder claims driven on pay of all shape, media, and this has huge reputational components to it. It has the ability to recruit and retain talent for organizations. So pay, it really, really is kind of an essential effort. So engaging in this, we do so with great purpose, but also with care and caution at the outset. And that's making sure that we understand, there are ways of doing this so that it is privileged, but that requires having counsel, and that can be in-house counsel or outside counsel. Normally it's a combination. Why? Because in-house counsel also provides business related advice. That is not privileged. Legal advice is. Outside counsel normally, Liz and I aren't retained to provide business advice. We're there to provide legal advice. So it helps sort of clarify that. The requests and compilation of information is such that we at the outset inform people of what the privilege is, even if they've been doing this every time. It's like giving someone the Miranda rights, in a criminal setting. We have a standard spiel. We refresh even for the most experienced. Let's go over how we're going to retain the confidentiality of our communications, who's involved in the communications, what the written communications are going to be. And this is particularly true with the robust sharing of documents on shared drives. We have a completely walled off shared drive. We normally are the custodian of that, but it doesn't have to be that way, but that's so we can control it. But all of that kind of nitty gritty detail, your counsel should be mapping out and collaborating with the company so that everyone, the key stakeholders, are involved and understand that.
Well, you missed one of the key advantages of bringing in a firm like you guys, and that is in the projects where I've been involved in, certainly with you all and other outside counsel, is they bring a certain subject matter expertise. Sure. This landscape is changing so quickly.
Sure.
I think it's important. You're not hiding behind privilege, and I've heard that sometimes. I mean, having these, you want to have a robust conversation, and do you think you have an issue? You want to be able to find the issues before a plaintiff's attorney brings those to you. So if you have these conversations under privilege, you can have an open, honest discussion without fear of them being disclosed. And I think it really does help get to root cause of problems, to being able to have a frank discussion that's protected from outside view.
My experience has been that if counsel or the head of comp has to go to the board of directors, CEO or the board of directors, and explain why we have a multi-million-dollar problem, their question is going to be, were you looking at this?
Right.
Did you have your eye on this? Because they expect that to occur. So that's something to keep in mind. Well, let's talk a little bit more about the mechanics, Liz, of how we actually determine our stakeholders, engage them, and let's move from the general to the more nitty gritty.
So right after getting privilege involved, because the remediation process, we need to be looking at these pay decisions. I have found that if you need to start with all of the engaged stakeholders in the room and helping you build the foundation of the project. If it's led just by legal or just by comp, you're going to miss some nuances. So get compensation, your senior leadership, HR, IT, legal. They're going to get in a room and help you understand that comp is going to tell you what our policies are and how it should work. HR is going to tell you that, yeah, but boots on the ground, this is what we need to be considering. And having all of those brains in and brainstorming how to group your employees and what factors control for pay and influence pay, that gives them all ownership in the model. They leave that room confident in the way you have decided how to structure it, or understanding some of the limitations on how to structure it, group size, etc. So that when you are then at the results stage, it's sort of the speak now or forever hold your peace part of the process. Because often if you don't engage them, by the time you're at the results, one of these individuals will come, yeah, but your model is flawed. These should, and then they don't own the results, and they're not engaged in the research because they think there's a foundational problem. So I think it's really important to have that conversation up front. And with this, I can touch on this, but with this group, you're going to get alignment on the components of pay that you're going to analyze, how to do groupings, the factors, the project timeline. Everybody needs to know what's coming and when, so they're prepared and they can kind of block off the resources, because there's usually a short time frame to do the remediation research and setting. And then also, developing that communication strategy get that set in the front. So I think that's just the foundation of the house.
I agree. And it's not only the buy-in and understanding, it's ensuring that you don't run the whole analytics and miss a fundamental factor.
Absolutely.
You don't want someone from HR at the end to raise their hand and go, oh, gosh, you didn't ask me, but we overlooked X. That's a disaster.
Yeah, I think I've had that before with a geo differential, where generally speaking, your policies do not call for a geo differential, and then we find out later on that in a certain segment, a geo differential had to be put in place, and then the analyses for that entire group were
Right, had to be redone.
Yeah.
Yeah, that's a fact. So there are lots of reasons for this. I would say as a practical matter, typically there are regular touch base pull-ups that involve all representatives from each. Each one may have more activity that prior week or the upcoming week than the other team, but at least everyone, the whole team knows what's going on, to Liz's point, when their turn in the box is going to come.
Yeah.
And so that they're ready in terms of research. Makes a huge difference.
Absolutely. No.
So Rick, let's next talk about what are we going to analyze? What are the components of pay?
Yeah. Well, I mean, as number one, as I think everyone knows, traditionally the focus has been on base salary. That is common to or hourly rate for hourly employees. That is the most common form of compensation, and it's typically what entities like the OFCCP focused on. But now I think there's a broadening awareness. There's been some developments in California, other developments that have put more eyeballs on incentive pay. And we're talking about bonuses, stock options, and so on. And of course, those can be analyzed. And we've all encountered situations where there's a desire to look at total compensation. And we've discussed this before. Our goal with all of these things is to model the decision-making process. And the challenge with trying to do some kind of one big cauldron total compensation is that includes each of those elements of pay that you see on the screen there are a different decision-making process, different considerations, different eligibility rules. I can tell you it's hard enough to develop a statistical model of base salary. It's nigh almost impossible to develop a statistical model that incorporates base pay and annual bonus and stock options and stock grants and so on. So we typically advocate, with just a rare exceptions, that we look at each element of pay in separately, basically.
Absolutely. Absolutely. One thing that I have recently seen more of is wanting to combine, and I think it's a little bit of a shortcut, understanding the work that's involved, but combining base pay with annual bonus when it's essentially a defined bonus opportunity, not defined absolute, but, and then the concept is, and employees, depending on when they get hired and what the balance is, you could have two employees both making a total comp of 100,000, let's say. Mine's 50-50, yours is 70 base, 30 bonus.
Right.
And there are some people think, well, they both get 100 at the end of the year. And I think it's important to say that the difference in how you are paid can be actionable, because employees may say, I want that 70, not the 50. I want the choice of how to do that. And the different components of pay are looked at differently in case law also. So
because normally they represent separate decisions.
correct.
Base pays one set of decisions, which has to be non-discriminatory. Bonus, a separate decision that has to be non-discriminatory.
Especially when the bonus isn't set and you're not promised, it's discretionary. Now, my own caveat on that is there are situations if the employee is given the option on how to do that, then you can choose to do a total, but that is really rare.
That's unusual.
It's really rare, but
final thought on this slide. The majority of most employees' compensation still remains base pay. So we've given you a menu, and this is, best depending on your comp system. But if you had to do just one box, you do base pay.
correct.
That is essential. That's kind of minimal assessment. And depending on your comp structure, have an informed discussion about how these others are included and how to do so, whether they're analyzed separately or in conjunction with the other.
Yeah, some forms of base pay are super straightforward to analyze. I mean, think of some commission systems are purely formulaic.
Yeah.
And then QED, as long as there's no alleged discrimination in how territories are assigned or something like that.
Correct. All right.
So let's talk about how we actually develop the model for our pay philosophy. And it starts with the similarly situated employee groups. Now, a few things that I think we need to be moving away from is just defaulting to EEO1 category. Those are just generally not sufficiently similar to be making an analysis.
Right. I mean, really, yeah.
And AAP job groups. So to the extent you are doing your pay equity based on your former 11246 AAPs, even down to the establishment-based concept, those AAP groupings, obviously they're still around for 503 and VEVRA, but you're not doing pay for that. That's not how you're doing the pay. Move away from that. And also workforce-wide. Essentially, a workforce-wide is your overall pay gap, right? And I think an overall pay gap, I think I've said this a number of times before, it's not pay equity, that is a workforce distribution. And doing an overall pay gap, I think, is going to continue to be a problem under this administration, because that is looking at not Title VII pay equity, and it is being sort of looking to how to reallocate your workforce and compensation. So moving away from those. You need to be living in the world of similarly situated employee groups. That's a Title VII phrase for it. But also be thinking about going to the scope of why are you doing this analysis? Do you have some other, does your state have a slightly different definition? Equal Pay Act has a slightly different definition. So working with legal counsel about what your reason for doing it, but being framed back in, how does the law that you're looking to comply with define the appropriate groupings? And that should be the start. But Rick, what are you seeing in some of the data? What is a starting place that you often see?
Well, ideally, we look at job within job, and sometimes you even fragment further, disaggregating jobs by, say, something like line of business or a manager. Because the first and foremost, we really do want to limit comparisons to people who are similarly situated, as the definition says. That said, in certain circumstances, for the purposes of because the approach I just described can, in some for some employers, leave you with very small, similarly situated groups. And for an employer that's still interested in evaluating these differences using statistical analysis, you then may look at combining, possibly combining similar jobs, using things like job family or job subfamily, also incorporating leveling like level. So there's a bit of an art and a science here, but I do think the tail should not wag the dog. The statistical analysis tail should not wag the dog, which is limit comparisons to similarly situated employees. And if you have some groupings that are too small, so be it. That's
What do you define as too small?
so a traditional rule of thumb is, say you're considering a binary comparison gender, you would normally look for groupings that contain at least 30 people in total, of which at least 5 are women and 5 are men. And that is with a reasonably compact set of control factors, we can run regression analysis on that grouping. But we can certainly explore flexibility doing less. But once you get below, say, 15 people, then you're looking at a more bespoke review.
So you mentioned control factors. Do we want to, what are some of those?
Yeah. So even within a similarly situated employee grouping, on the next slide, we list some, there are some important differences among those employees, and the virtue or the reason that multiple regression analysis is the gold standard when doing pay equity analysis. It allows you to answer the question within this similarly situated employee group, are there statistically significant disparities between pay for, say, men and women after simultaneously controlling for differences in their characteristics? And you can see a long list of factors here, and this is not exhaustive. These are some of the more common ones. You may notice there's almost a fanciful element to some of these things, because I'm an optimist in life. I love the idea that employers track relevant prior work experience, or they have some kind of skill inventory. But I can dream, can't I? On the flip side, there is a risk with these regression analyses. It's called overfitting or oversaturation. You have to be kind of thoughtful about limiting the control factors to what really matter. If you overstuff the analysis with too many control factors, the statistical analysis breaks down, and that's what that final bullet there is.
What I'm noticing here too, you in the prior slide we were talking about using job title as an organizing principle.
Yes.
But I also see it here as a control. So I think there's some of these can either be controls or grouping methods.
Right.
So if job title is too small,
Yeah,
maybe you go up to department
yeah,
and then control for job title in the measure. So these are things that you can be thinking of as you're developing. Often, I like to start with my dream scenario. I'd love to do everybody by job title. And I get Brett to run me a report to show if I go up by job title, how many of those titles are sufficient to do regression.
right.
Full stop those are regressions.
Yeah,
The ones that aren't, then we look to see what do we need, which ones do we need to combine and how do we combine them?
Yeah.
So,
or do we combine them at all? Yeah.
or do we combine them at all? Right? Can they be combined with any of them that makes sense?
Yeah.
And so that is some time you also need to be putting into your developing your model to be thoughtful about how you build these groupings.
Right, right. And one last point, I will say, productivity performance measures. Economic theory says people should be paid their marginal product, how productive they are. And the central challenge with all pay equity is it's not, in most jobs, you cannot directly observe someone's productivity. Performance reviews try to do that, but we all know that's not perfect.
True. And one other thing, often my experience has been some of these factors just don't live in the data. I mean, it's
Yeah.
wonderful. So this also can be some of these factors can be used back to when you're doing cohort analysis,
Correct.
particularly relevant prior experience. If that was a driver of initial pay determination, because often where you start with your pay influences your pay for quite a bit going forward. So that's always a factor to look at for someone who's worked in an organization, particularly say for 5 years or less within an organization. What was their starting pay? How was that starting pay set? And often that may be 3 years ago, and they're like, oh, I don't know. You know, that's usually the answer, honestly.
Yeah, starting pays.
Right. Well, and I think that goes to the point where when you pull the data, there's a lot of data fields, and to Rick's point, maybe you don't put all of them in the regression because then it gets a muddy, but you keep them in that Excel file because once you do that individual assessment, those data points may be relevant for consideration. So never delete a column. So want to move on, and Rick, can you lead us into a discussion of interpreting the results?
Yeah, sure. I've gotten a lot of questions recently from clients and attorneys about how do I interpret a multiple regression analysis with a low R squared? What does a low R squared mean?
Let's start there.
When we think of there's variation in pay, say you're looking at annual salary within an SSEG, some people earn more, some people earn less. And we want to explain using the factors in the model, help us explain that variation. And sometimes you have factors in a model, especially with a more regimented pay structure, where the R squared can be very high. You have literally the factors in the model explain 88% of all the variation in pay. But often, especially with more kind of, I don't know, professional jobs where there's more subjectivity, and especially when you're looking within job, the R squareds can be quite low. We're talking like 20%. That means that there's something else explaining the variation in pay for these people that's not in the model, and the model really is only explaining a small share of the variation pay. What I tell people in those circumstances is if you have a flag adverse to a particular demographic category, that is still a meaningful result, but it needs to be interpreted more carefully. It's more likely in those circumstances with a low R squared that there is some other factor not in the model that could be explained, and potentially it's a non-discriminatory factor that's explaining the variation in pay. So this happens a lot in some workforces where they're either the employer doesn't track a lot of the pay drivers, or there's simply just more a subjective element to pay.
What I'm hearing in that is the model is not really predicting pay, which means the predicted pay in the model isn't accurate. And if you make adjustments based on just the model alone, you are not making accurate adjustments based on how you pay.
Yeah,
what I'm hearing.
What you often see is a job where there's true range of salaries is 80,000 to 160,000. The model doesn't understand why that range is so wide. And so all the predicted values will be between 110 and 130.
Right.
Mhm.
So this means the individual research, the individual assessment, looking at each of the outliers is even more important when you have a low R square, is what I'm hearing.
And then one final note on practical significance. We've talked about traditionally statistical significance, and it's still true, is of paramount importance. That is Supreme Court precedent. If you have a statistically significant disparity, attorneys correct me if I misphrase this, then there's almost a burden shifting that goes on. Then the employer has to explain why that's not discrimination.
Correct. It's part of essentially making a prima facie case, but it in and of itself does not demonstrate discrimination. And that's the point, that if there are sufficient justifications, I mean, one answer is if we can justify the differences that are there, even with a statistical model, we don't have to make any adjustments.
Right, right.
And so that becomes, that's why this privileged discussion, once you interpret the results.
Yeah.
The R square pattern, is the model sufficiently accurate? Is it robust enough? And I've certainly had occasions where when we've gotten a low R square, meaning the predictive power of the model isn't quite what we'd like it to be, we go back and say, could we introduce other factors? Does our comp data enable us to make a model that has greater predictive power? Sometimes yes, sometimes no.
Remove factors.
Or do we remove
that are
factors? Are there ways of doing this? Now, this isn't just jiggering things around to get a result we like. It's having to have a model that is reasonably accurate. Then once you're there, then you go through that assessment, and then you make the ultimate decision on interpreting the results. Do we have flags that we otherwise can't justify or explain, and are we going to make adjustments?
Yep.
All right, folks, we are really coming up to time, so I want to turn to a couple final thoughts, and since I'm talking, I'll go ahead and lead off. I think the very important thing is setting your timeline so that you have a sufficient time to do appropriate review and making accurate remediations that are in no way driven based solely on race or gender. I think that is the foundation for pay equity under the current administration.
Yep. Right. My final thought is data. The Trump executive orders use a lot of florid language, but one term that keeps on coming up is merit. So if you can track those productivity measures that influence people's pay, performance, anything that is tangible, that's going to make your life so much easier in understanding and justifying pay differences.
Final thought I have is that illegal DEI, whatever you're doing in response, do not diminish your attention on assessing your pay systems. If anything, in my opinion, it's become more important than ever. I will tell you that the EOC charges we're seeing do delve into this, and they do a multi-year dive. The plaintiffs' counsel are all over this. So don't be distracted by some of the other noise and some of the changes at federal contractors.
This is good work that needs to continue.
This work has been and continues to be, I call it core compliance activities. And I hope that everyone takes that to heart. So with that, I see Sarah's on. That means our time has run. And I want to thank Rick. I particularly want to thank you for joining us today. It's super. And Liz, of course, and thank all of you for spending part of your day with us. Thank you.
Awesome. We'd like to thank you all for joining us today. If you have any further questions, please email us at info@FortneyScott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.